Hey, a quick shout out before we dive into today's episode. Million Podcasts has named Beyond the Mask the #1 anesthesia podcast of 2026. Congrats to Sharon, Jeremy, and everyone behind the scenes making this show happen. And a huge thank you to you for listening and sharing the show.
In the long history of AANA, there has only been 3 amicus curiae filed by NANA in 1934 and AANA in 1982 and 1989. These briefs centered around the climate at the time. Dagmar Nelson won her trial in 1934, solidifying the rights of nurses to administer anesthesia. The briefs in the 1980s centered around protection of nurse anesthetists under antitrust law. We welcome back Richard and Sandy Ouellette to guide us through these times and tell us about the relevance today.
CRNA Financial Planning is a sponsor of Beyond the Mask podcast. Investment advice offered through Private Advisor Group. Nothing in this podcast should be construed as investment advice. Plus, did you know listening to our podcast can earn you Class B credits? For details on how to submit, visit the CE credit section at beyondthemaskpodcast.com. Welcome to Beyond the Mask, innovation and opportunities for CRNAs and advanced practice nurses, with certified financial planner Jeremy Stanley and CRNA Sharon Pierce. Jeremy Stanley has worked with CRNAs for more than 23 years, and Sharon Pierce is a former president of the AANA and the NCANA. Join us as we leave the operating room and learn the latest in the CRNA and advanced practice nurse industries. Beyond the Mask starts in 10, 9, 8, 7.
And actually, Jeremy, they were practicing during 2 of the 3 amicus curiae that the AANA submitted.
Wow. Yeah. I mean, it's great to have people that were actually in the room to talk about some of this stuff. Sandy, Dick, welcome back to the show. It's always great to have you guys.
Always a pleasure to be here.
Well, we're looking forward to it today. So, Sandy, why don't you kind of kick us off telling us what is an amicus brief anyway?
An amicus is referred to as a friend of the court. It is filed by either an individual or an organization that is not a party in the legal case. And we were not a party in any of the 3 that we filed in almost 100 years. But it was filed because it assists the court by offering information and expertise or insight that has a bearing on the issue of the case. In American law, an amicus typically refers to an intervention, if you can imagine, a person or organization who requests legal submission as to offer relevant, alternative, or an additional perspective regarding the matter in dispute. And you'll see that as we describe these 3 that were filed. It is often used in cases where there is broad public interest or involved when the civil rights are in question. That's the most times it's used. Whether a court, though, will consider an amicus, you can file as many as you want, either an individual or an organization, but the court may not consider it. It's at the total discretion of the court, the judge. The phrase was derived from Latin, and the term dates back to around 1605 to 1615. Now, since our organization in 1931, NANA, the National Association of Nurse Anesthetists, filed the first amicus. That was 3 years after we were formed in 1934 to assist Dagmar Nelson in her California case. It was filed by NANA. Dagmar Nelson was not a member of AANA at that time. She was too busy solidifying our right to practice as CRNAs. The other 2 were filed when Dick Ouellette here was on the board in 1982, and then when I was on the board as president in 1989. And that's the only 3 in almost 100 years that have been filed. And so we do have some insight way back to when we were on the board that might be relevant and of interest to our listeners.
So, Dick, tell us about the first amicus that was filed by Nana on behalf of Dagmar Nelson, even though I know you weren't there.
No, I wasn't.
And I wasn't either, Sharon.
Okay, the amicus was filed by Nana in the Dagmar Nelson case, in which they were really kind of being supportive of Dagmar Nelson. This was among the only court trials that tested the legality of nurses administering anesthesia. The trial itself lasted about 12 days and ended favorably for the defendant, Dagmar Nelson. However, it was then appealed to the Supreme Court of the state of California. It was filed by an attorney, Kenneth Gill from Cleveland, Ohio. The brief addressing the matter is 14 pages long. An appendix of supporting findings in numerous states was attached, bringing the document to 18 pages. Frank versus South, the case of 1917, was also used to support the arguments by the attorney Guild.
It's interesting, and I'd like to hear a little bit more about these key points in the first filing and how this was actually helpful.
Dick and I both have copies of the amicus that was filed in the 80s, but I did not have the one in 1934. So I called our archivist, Hathaway Hester, and she sent me a copy. And that's a real prize because I have that. I have all three amicus stacks in my home library here. And so I looked through for the first time, actually, that particular amicus. And it was interesting, some of the things that were brought forward as a friend to the court there. In the opening statement, and I will read this, says the onset of the economic disturbances of the past few years, agitation has sprung up in certain quarters to restrict the right to administer anesthesia to regularly licensed physicians and surgeons, thus eliminating the nurse anesthetists from the field of anesthesia. So we were eliminated. We believe there is a direct distinction or relationship between the economic disturbance and agitation against the nurse anesthetists. And Nancy has brought that up time and time again in these historical segments. It went on to say, we believe it is a fact that the vast majority of surgeons throughout the country prefer nurse anesthetists. We believe that the vast majority of surgeons who testified in the lower courts prefer nurse anesthetists. So that was good. This means must be due to the fact that the nurse anesthetist is not only proficient in performing her duties, but has contributed greatly to the advancement made in the art and science of anesthesiology, which, of course, the McMeachams were going around about the same time saying that we had done nothing. The NANA represents about 1,100 members. Can you imagine? In 1934, we were a growing organization of 1,100 members who are actively engaged in the administration of anesthesia, and these members are distributed throughout the United States, and they were. Major questions addressed by the amicus was, does the administration of an anesthesia by a registered nurse under the direction of a regularly licensed surgeon constitute the practice of medicine within the meaning of the Medical Practice Act? Evidence in support of Nelson included the anesthetist was under the direct supervision of the surgeon or the assistant. Evidence of appellate Chalmer Francis said, but it is common for nurses to give hypodermics pro re nata, which is PRN, I'd forgotten that way back sometime, or as needed. He stated the nurse is so doing is not diagnosing or prescribing. He therefore answered his own concern in favor of Nelson. Now that was interesting because he was a physician that filed the suit against Dagmar Nelson, and what he just said supported her in the trial, and it was in the amicus as well. She was not diagnosing or prescribing, but she was administering an anesthetic at the prescription of the surgeon in the surgeon's immediate presence. So the surgeon prescribed, the surgeon or the assistant was present, and it was not the practice of medicine. And she went on, of course, in 1936. Francis took it to the Supreme Court of California, and she won that too. So that is what that one said, and it was really, really good. Now, what is the importance of Frank versus Scythe in 1917? Frank versus Scythe was settled that year. Now, that was prior to the enactment of California anesthesia statutes in 1920. So Frank versus Scythe preceded their statutes. It prohibited administration of anesthetics by any person except to any person who administered it at the prescription of the surgeon. There were no prosecutions of nurse anesthetists in Kentucky after 1917. In Frank versus Scythe, it was concluding the mere giving of medicines, which are prescribed by the physician in charge who has made a diagnosis and determined the disease that has to be addressed, is not the practice of medicine, and it is certainly lawful for nurses to do that. Chalmers Francis continued to argue, but the custom for anesthesia is to be administered by physicians. Now, you know that wasn't true. Back in 1934, they didn't have but a handful of them, and that was quickly shot down in the brief. At the time, only 3 states, at the time of 1934, only 3 states, California, Ohio, and West Virginia, had statutes that even mentioned anesthesia, and none of them, not a single one of them, prohibited administration of anesthesia by a nurse anesthetist. Yay, yay, yay. So after that 12-day trial, as Dick said, in 1934, Nelson won the case, and she also won the appeal in 1936. And we all practice today because of what this woman did, who had not yet become a member of the AANA, but she did become a member when things settled down for her in the early 1900s. And she apologized to Gertrude Fife for being a little tardy, but she said she had been quite busy. And she had.
Well, those arguments still stand for us today, Sandy. Whenever we were fighting physician supervision of nurse anesthetists in 05 to 08 in North Carolina, those are the exact same arguments that we used then. We don't diagnose. We just facilitate a cure by providing anesthesia. So those same arguments still stand in this century, too.
Yeah, most legal briefs that you look at always reference Frank versus Scythe and Dagmar Nelson. It goes all the way back there. That is so solidified in the law. And we can't thank those people enough for doing that. Can you imagine how hard it would be to do today?
So, Dick, tell us about the Jefferson Parish amicus of 1982, and you were there for that one.
It was early on the board of 1982. Pat Fleming was the president. I was treasurer. And we had been approached by several individuals who were concerned about this antitrust case that was in Jefferson County and parish, I mean. And what they were concerned about was not that we were involved in it, but some of the language that was being proposed or stated in many of the papers that had been presented was really gave a bad misconception of what nurse anesthesia was. And so the AANA, as a board, we got concerned that maybe we needed to do something about that and end up doing an amicus. We really wanted to just clarify some of the information that was put out in those other documents or by other people who had presented, to clarify some of the roles of what they said nurse anesthesia was about. And the board at that point decided that we would go ahead and present the amicus. However, we would stay neutral on whether we were on the side of Hyde or we were on the side of the district. So as a result, we went ahead and adopted the position with regards to exclusive contracts the AANA had not actually adopted a position with regards to exclusive contracts between hospitals and anesthesiologists. The issues before the court related to staff privileges between an anesthesiologist and a hospital, and issues pertaining to CRNAs may be different. So the points that we were presented were historically nurse anesthetists preceded anesthesiologists as administrators of anesthesia. CRNAs are highly educated, must continuously demonstrate their ability and education in biannual recertification programs. We've completed presenting these points in our defense on our practice, saying nurse anesthetists practice in every state and provide more than 50% of the anesthesia services at the time in the United States. What was interesting with all of the presentations that were made at the time, the witnesses at the trial did not include any nurse anesthetists at all. And yet nurse anesthetist was being discussed in some of these presentations. So the lack of presentation by the nurse anesthetists in the trial is reflected in the misunderstandings concerning the roles of nurse anesthetists, which are reflected in the transcripts of the trial court proceedings and in the district and appellate court decisions. The AANA was and still and remained neutral in the cases, but issued the brief to clear up all these misunderstandings of what nurse anesthesia or nurse anesthetists are and what we do.
Are you looking to transition into independent practice? AANA and Beyond the Mask are here to help you thrive as your own boss. Visit the 1099 CRNA Institute, taught by Beyond the Mask host Jeremy Stanley and Sharon Pierce. This comprehensive educational series provides detailed guidance on business structure, legal and tax implications, and financial management tailored specifically for 1099 CRNAs. Lean into the feeling of freedom and embrace the opportunity to be your own boss, with AANA as your partner on this exciting journey toward independence. Enroll now and gain the knowledge you need to navigate the business side of independent practice. Learn how to choose the right business structure, understand tax strategies, and manage contracts and finances with confidence. Plus, enjoy a special 20% discount using the code BEYOND1099 at checkout. Visit aana.com/1099 to learn more and start building the future you want. The 1099 CRNA Institute. Thrive as your own boss. Remember to visit aana.com/1099 and start using the code BEYOND1099 for a 20% discount.
Both the 82 and the 89 was signed by a number of attorneys for the AANA, but Gene Blumenreich was our legal counsel for 26 years, was he not? And his name was all over it. So I was a little fuzzy as to what was a real spark that many years ago that had us file the 82 and 89 amicus. And I contacted Gene by text, and he also, it's been a long period of time, but I do know this was happening. Vinnie Bond had been discharged from a hospital, and he brought an antitrust case in California. And we'll talk about that a little bit more. So both of these amicus was circling around antitrust law. And I do believe that we were really hot on that because of what was happening with antitrust that we'll tell you about in a minute, and why we had to be recognized as protected in certain circumstances by antitrust laws. But we will get into that. But it certainly had a lot to do, I think, with that as well.
Yeah, Sandy, and listening to Dick, I mean, the misconceptions and the falsehoods out there about nurse anesthetists at the time is still the same pattern we're dealing with today, which is interesting.
Jeremy, it's fake news.
Fake news. I like that.
Used to. It's always been. That's the only way they can smear us. They can't smear a good record, a good education. We are the poster childs of APRNs. So they have to attack us there,
Now, I mean, the first amicus in 1934, the second 48 years later in 1982, and then here comes 7 years later and we file another amicus. Can we talk a little bit more about that and some of the reasonings and what happened there?
Again, it was antitrust. But we weren't in it. So it was to the Supreme Court of the United States, and we filed an amicus that the court accepted in the Supreme Court. And it had a number of physicians' names. They were all chiropractors
Huh.
that were petitioning, filing this charge against the Joint Commission for Hospital Accreditation, the American Medical Association, the American College of Physicians as respondents in this case. And basically, their charges were, you're being anti-competitive in what you're doing and laying out for us. So to tell you a little bit more about that, the points of interest in the litigation for AANA in this particular case, the courts recognize that CRNAs and MDAs are direct competitors for antitrust purposes. But that was not recognized until that was recognized in 1986. Benny Bond, and we'll talk about what had to happen in his case to get the Olds through the gate. But he did win the only antitrust case for CRNAs ever in 1986. CRNAs function in a variety of practice situations, including independent contractors. The Joint Commission sets standards which covers CRNAs, and the AANA has a vested interest that the standard-setting process not be manipulated for anti-competitive purposes, and we were suspecting that was the case in this particular case. And as I said, the case was brought against 4 chiropractors. The Joint Commission had set standards affecting competition between physicians and non-physicians. It was very clear. The American Medical Association, in its medical ethics, had stated it's unethical to associate with, quote, unscientific practitioners such as a chiropractor. In the 1970s, Joint Commission took the position that a hospital with chiropractors on staff would lose their accreditation. That's pretty heavy, huh? Pretty heavy. And Joint Commission was manipulated by the American Medical Association to promote and expand the boycott. So it was a conspiracy between those two. So the Wilk case is an example of the Commission's ability to limit the ability of non-physician healthcare providers to substitute physicians. Without the protection of antitrust laws, physicians, through dominance of the Joint Commission, can effectively control competition in the healthcare industry. This amicus recommended the court grant certiorari to eliminate the important issues raised in this case. And what that is, I probably didn't pronounce it, but my law knowledge is somewhat limited, is an appeal to the U.S. Supreme Court. And if 4 justices agree, it will be heard. So what is it, 9 on the Supreme Court? If 4 out of 9, doesn't even have to be the majority, agree, it will be heard. And this was heard. And we were all dancing around that Benny Bond, and I see Benny Bond. I get a picture with him every year at AANA meeting. Wonderful fella, but it's all about that case he brought in the early 80s that went until the 1990s, and Dick will tell you about that. But these were the 3 that were filed. And one was to support Dagmar and the legality of nurses administering anesthesia, and the other 2 were dancing around antitrust law.
Now, is Benny Bond still with us? I don't think I've ever met Benny Bond.
Well, when you're in Boston, Sharon, I will introduce you to Benny. I've got pictures of him. I'll send you one of the last 2 years. Me and Benny get our picture made every year, and I will send you that. But you'll see him, and I'll make sure that you, and if Jeremy's there, meet him in Boston, because he rarely misses an AANA meeting.
do send it. I may have seen him and just not realized it was him.
He is from India. He's Indian, but he spent his whole life here in the United States as a nurse anesthetist in California.
Well, we need to get him on the podcast for sure.
Yeah.
Yeah. So we've been dancing around talking about him. Maybe his ears are burning right now. But Dick, why don't you tell us about the case that we've been dancing around?
The Vinnie Bond case actually ended up coming to the board of directors again that I was on in 1983. And the case was kind of interesting, and he wanted us to get very much involved in it. We helped them out with some information and all, but we were already tied with the Oates case, working with their people, and we just really did not have enough resources because not only did Vinnie Bond come forth, but there were several other people who came in who wanted support for what they claimed to be their antitrust cases again. And let's face facts, back in those days, we weren't as big as we are today. We didn't have all that much money in that respect as well. So anyways, with the Vinnie Bond case, although it was listed as an antitrust case, it in short, the charges centered around dependent hospital and the MDA conspiring to eliminate competition and exclude nurse anesthetists. That was the claim that had been made. However, when you turn around and you look at the antitrust litigation, that's a three-pronged process to get victory on that. It's having market power, damages competition, damaged consumers. Well, he didn't have the first part of the market power. He lacked the market share. There were several hospitals in that area. The hospital that he was involved in, they wanted to go strictly to a physician baby type. I guess that's exactly what they looked, and they wanted to eliminate him because they want to have just a complete physician service. He did not have antitrust with of the marketplace because there was 8 other hospitals in the area.
And you have to have it all.
And you have to have it all. And so he was able, so that maybe he would be pushed out of one place, but he still had market share. He could go to work at any one of the other hospitals.
But it wasn't like that in Montana, where Tafford Oates was.
So recovery from anti-litigation, therefore, needs to follow those 3 steps. And he did not feel into that. For whatever reason, defendants had argued in the lower courts to dismiss the case since anesthesiologists and CRNAs were not in the same market, and Bond lacked the standing in the antitrust case. The arguments actually prevailed in lower court. Bond.
But before you go on, Dick, you see how big that was?
Mm-hmm.
The lower court had ruled that nurse anesthetists are not protected under antitrust laws. That's why AANA had to get involved, because it affected every CRNA in the country. Did it not, Dick?
Yes.
We knew he did not have an antitrust case because, as Dick said, he lacked market share. But the lower court came out with a ruling that could have been deadly to us.
Yeah.
So go ahead, Dick.
Okay, so then the Bond case appealed at the U.S. Court of Appeals in the Ninth Circuit. And the question before the court was if nurse anesthetists and physicians are participants in a single anesthesia service market, or whether they each participate in their own market. Is there reasonable elasticity of demands between services provided by the nurse anesthetist and the anesthesiologist? In 1985, the appeals court ruled that under certain circumstances, CRNAs working with physicians other than anesthesiologists have a standing to bring a federal antitrust case in certain circumstances prescribed in antitrust law. And perfect example for that is the Oates case.
Yeah, you see, we could not let that stand, that lower court ruling. And because it was changed, it doesn't mean that every nurse anesthetist, if you're hospital employed or you're physician employed, and supervised by anesthesiologists, you probably wouldn't have an antitrust case. But that was not true with Tafford Olds. And the year after this amicus, the year after his lower, 2 years after his lower trial, 1985, in 1986, as soon as that change was made by the appeal court, Olds versus St. Peter's Hospital proved in federal court in Montana that the hospital administrators and anesthesiologists conspired to dismiss him from clinical privileges. And this is the only, as I said earlier, antitrust case ever won by a CRNA before or after. He was number one in a place where he had market share. And the second thing was, it was a damage to competition. He had all those boxes checked because, and it was damaging to the consumers to dismiss him because he would do epidural, OB epidurals, and the physicians that there didn't want to do them. And so he and his wife, Laurie Olds, is also a CRNA. She was not working at that particular facility, but was working. And they were like a dog with a bone. They collected all this. They had all this. I think you did a 2-part pod.
You did.
Well deserved for this one moment in our history that the Olds won their antitrust case.
And they've never spoken to anybody else about it except for us. So
Yeah.
you can go back and you can listen to it. It's very compelling.
Oh, yeah, it is.
Hey, Dick, I just want to know, I mean, you were in the room. I mean, and that's what makes this so interesting. I mean, do you think now looking back on it that you and the board and the AANA really understood the magnitude of what was going on? And what was it like in that room for you to be there and all this going on?
I don't think we actually saw the ramification of what it was going to be as we moved on.
Particularly in 2000s and all.
Yeah, and particularly now. I mean, this was the early 80s and all.
Right.
But the thing that the board was so more concerned about at the time is having the misconceptions of what nurse anesthesia and nurse anesthesia practice was about. So as a result, we really wanted to go ahead and get this amicus filed, to clear up the misconceptions that had been written in some of those papers. They are talking really kind of derogatory about nurse anesthesia practice, making it seem like it's just, a handmaiden type of a situation. We were really compelled to want to go ahead and get those points clarified. Then, as I mentioned, right after that, we had several other people who Vinnie Bond for one, and a couple of others that came in with possibilities of antitrust. Okay, we looked at them, and they really did not meet the 3 criteria. And then, of course, we had limited resources at the time and was not really compelled to do so, although that we would be available to help them and their attorneys with documents if they needed it as such. And so that's where we were at that time. And obviously, with the Bond cases, we provided him also with information and all of that, but did not really get on board completely, in his defense in that case.
Hi, this is Jackie Rolls, President and founder of Our Hearts, Your Hands, a global support anesthesia community. We'd like to thank all of our prior donors and also say that we are accepting donations, welcome donations, to send a nurse anesthetist or even a nurse from a low-resource country to get further academic education or attend professional conferences or even equipment for some companies. Thank you so much for your support.
Dick was on the board from 1982. I came on in 1984. So I was not there with the first filing of the amicus, but Dick was there from 1982 through 1990. So that was really volatile years for the AANA in many, many different directions. And he happened to be there that long because he was the first CRNA to be elected to serve as president twice. So he was our president of AANA in 1985 and again in 1990. And so he followed me in 89 for his second run as president of AANA. So he's seen it all, and particularly direct reimbursement. He saw it from day one. He walked the walk and talked the talk with Peggy McFadden, and both of them were there the entire time. And Peggy McFadden was elected again the second time as president to sort of to clear up some of the payment things through the physician review payment process or whatever it was, because we knew in 1989 with direct reimbursement that we had done all we could do at that time for parity in payment for the nurse anesthetists. However, we knew it was not over. And Peggy came back, and it was Peggy and Dick that were the first to hit the hill, opening doors for us to get through. And both Peggy will not be able to join us in Boston, but Dick, myself, and Jan Menino will be doing a panel discussion on direct reimbursement. It is the landmark piece of legislation which has not been duplicated before or since, that changed the profession and positively affected every single CRNA in it. So these young folks coming on board that's making these salaries today, you're very welcome, because if that had not happened, it would be a very different playing field today, in my opinion.
Ira had to have been involved in some way about this. Dick just talked about how we didn't have a lot of money at our disposal. And when I was NCANA president in 01 to 02 is when Ira run the amendment for us to increase our dues and start the strategic reserve fund. So do you think that her thought processes, since she was probably involved in this whole ordeal, was because now we have a war chest, and it's purely Ira's idea whenever we raised our dues, because then we got $132.50 back for each member when I was state president. They raised the dues, but there were a number of years that it did not increase the money back to the states, and it went to create that reserve fund.
Yeah, I'm glad you brought her up before Dick speaks, because Ira was very much involved. In fact, she mentored Gene Blumenreich. He will tell you that, because he knew nothing about nurse anesthetists. And she had a lot to do with a lot of the advances in those days.
When we were working and getting started with the amicus, it was being done through the Office of Fine and Ambrose, which was in Boston. They brought Ira Gunn in for that meeting, and for her to meet with the people who were going to be developing the thing. She had a lot to do with all the input of what was going on and what was being put into the amicus. I was there as well because I was the link, because Pat Fleming was here in Greensboro, North Carolina, and I was on the phone calling her, letting her know what we were discussing back and forth to make sure everything was being what we were planning on doing it, and how the amicus was going to end up being composed and put together, and us also stressing the fact that it was going to end up being neutral on our part of support for either of the defendants or the plaintiffs in that case. But Ira was really in there from the very beginning, was involved in that case very much.
There's people that say that Ira wrote the brief. I'm glad you brought that up. And it has a lot of Ira.
I mean, when you read the brief, I can just hear Ira talking in the background with it, because it's a lot of it is exactly her wording and how she used to phrase things and all.
Speaking of Ira, she helped in so many ways, and I think we did a podcast on Ira Gunn.
We did.
Time. Before her death, in her assisted living home, wanted to do something special for her. So I had the idea to get a book together with letters and pictures. I contacted every CRNA I knew that had crossed with Ira on many paths throughout the years, and the response was overwhelming. I got wonderful input. I put a book together, and Peggy McFadden, myself, and Rita Rupp, who was a senior staff member at AANA, we went to El Paso, and we spent a day with Ira, and we read every single one of those letters to her and talked about every picture that was sent. And that really lit up her world. That was so meaningful to her. And then, of course, her funeral was at Arlington National Cemetery during the time that we were there for mid-year. They suspended the meeting, and about 400 nurses went to Arlington National Cemetery. And everybody that wasn't a part of us was asking, who died that we missed with all these people here? And it was Ira Gunn.
I went to that. Remember, they had that huge carriage.
Yes,
and
yes.
it cremated, and they had the little bitty urn sitting
And
on top.
Lydia Edge videoed all that, and she's really quite good at doing that. And Mara McCullough was one that got all of that together, and it was just phenomenal send off for a real giant in our field.
Yeah, so as we kind of wrap up here, can we discuss a little bit? I mean, because this is a lot of stuff. It was very important. Now we look back on it, we know the weight and importance of it. But what is the relevance today? You mentioned a little bit of it a few minutes ago, Sandy, of all this work that went on.
Okay, I'll start, and maybe Dick will have something to add. The relevance today is there were courts that were disregarding the role that nurse anesthetists play throughout this country. It had to be cleaned up. And the only way to do that is through an amicus, where you're not really involved in the case, but you can have input into what we are, what we do, and educate the court. It's a friend of the court, actually. So that was very important. I do not know the cost. You would be interested in that, Jeremy. What was the cost of this? I'm sure it was expensive for us at the time, but not as expensive as it would be today. And I don't know what the cost was, but I know what the cost would have been had we not done it. And we had to solidify that it is within the legal right for nurses to administer anesthesia. That was Dagmar Nelson. And that when the Benny Bond first case went down in the lower court, it had to be corrected that nurse anesthetists in certain circumstances are protected under antitrust laws. And that it was very, very important. And there may be another, it keeps us on the playing field as relevant, strong providers of anesthesia, not only through our licensure, our education, and our practice, but also support from the legal system, which is quite relevant. So we couldn't have not done it. What would it be like today if we hadn't done it? It would be weaker for sure, and there'd be a lot of more places to attack. And these are on record forever. Like Dick and I have the green and the yellow copies of the 1980s amicus, and I now have the one from the AANA archives on the Dagmar Nelson. So it seems, and you asked Dick a minute ago, did you understand what this would do? I think so many times when you're there, you're making the decisions, we cannot see and understand what a far reach this is going to have. It's just like a founding. When I signed the founding document along with Ron Kalk for the AANA on the founding of the International Federation of Nurse Anesthetists in Teufen, Switzerland, I had no idea what it would be. And you can't when you're sitting in that one little moment, focusing on that one little thing, how it can expand and be relevant not only for all the nurses in the United States, but nurse anesthetists globally. So we have to keep picking our battles, fight them to the nth degree, and keep winning. Dick, do you have anything?
I'm thinking back when the Oates first came to the board of directors with their attorney asking for support for this antitrust case that they had. And they had presented the situation. I think a lot of it was really kind of foreign to all of us who were on the board. At the board at the time, we were divided between educators involved with nurse anesthesia, with anesthesia programs and education, and clinical practitioners. But we didn't have any person on the board at the time who was an independent contractor, work except we were the hospital employed, a physician employed. So it was really an education to all of us as well. And, I'm glad that we paid attention and really listened and decided to really go ahead and to support that this case most likely has merit, but didn't see how it would affect us years from then. And so I still remember them coming aboard second time, a third time they came to the board. These were separate boards each time, so they ended up going. And I still remember the day we got notification that they had won their case. So we were very, very pleased with them and all. And certainly they were appreciative of the help that the AANA had given them during that process. So it's interesting. You never know, when you're sitting on a board when somebody comes up with something, how much it's going to maybe affect you, not at the present time, but futuristically. If there's anything, will it have an impact on future practice progress of nurse anesthesia? So,
and I must say in closing, it was a real honor, a true honor to serve on the AANA, to serve on IFNA, and to still serve in ways that we can. And I think these podcasts help us help the new people understand some of the things that have brought us to where we are. And it helps them open their eyes to things that they may need to address to keep us where we are. Because I'm going to be very unhappy if we do not stay where we are today. And we are a well-recognized specialty in terms of anesthesia services throughout the world, really. Podcasts have helped a lot.
Well, you know what has helped is having you, Nancy, and Dick. I mean, painting the picture that wasn't being painted at all. As we know, this isn't getting taught to the new residents. It's not on the exam anymore. And, we're doomed to repeat history if we don't understand it and know it. To you guys, you were in the room, you've put time into this, you've been phenomenal. Sandy, you've learned new technology and new ways of doing stuff.
I'm still trying.
You and Nancy, I mean, we're just so proud of what you guys have been able to do. And we could not have done this without you. So you guys you both dedicated your career to nurse anesthesia, you and Dick and Nancy. And here you are, you're retired, but you're still doing it. You're still giving back.
Jerry, I must say, I was on a Zoom advisory committee for the school yesterday, and it came up that I was director of the program here for a quarter of a century. And when I got thinking about it, I've been heavily involved, as has Dick, for half a century. So when we get to the 100th anniversary of AANA, we walk the walk and talk the talk, for a half a century.
Half of the entire profession. That's...
Yeah.
Be impressive.
Yeah, but only half, Sharon. Only
half. The best half.
Well, listen, Sandy, Dick, thank you again for being on with us today. It's always a pleasure. And Sharon, I'm going to say that's a wrap.
I think so.
Thank you for tuning in to Beyond the Mask. If you enjoy the show and want to help us grow, the best way to support us is simple. Leave a review on your favorite podcast platform, share the show on social media, and tell your friends. Your word of mouth is what keeps us going strong. We're proud to consistently rank in the top 50 medical podcasts nationwide and to be #1 in the CRNA community. All thanks to listeners like you. Your support helps us stay there, and we couldn't do it without you. We'll see you on the next Beyond the Mask.